am taking the class from section 56 of the CPC, which relates to execution of the decree by the mode of detention. I told you in the previous class that the decree can be executed in two ways. One by attachment and sale, and also by sale straight away. Or otherwise, another mode is by detaining in civil prison, the judgment data. And what are the conditions that has to be complied with before a decree holder files a petition for detention? I have already told you, but today I will continue the lecture on the very same topic from the end of that particular portion. I told you in the last class, a woman cannot be detained in execution of a decree. That the woman is always exempted. Therefore, you keep it in mind. A woman cannot be detained in civil prison in execution of a decree. And the next is, what are the amount and also the period for which a decree by a judgment debtor can be put in civil prison or arrested and detained in civil prison. Then there's a amount is also fixed. If the decree is for, if the execution is for in respect of a decree for an amount less than 2,000, then there cannot be any order for detention. If it is above rupees 2,000 and below 5,000, a judgment debtor can be placed in detention for a period not exceeding 6 weeks. And if the amount exceeds 5,000 and more, then a judgment debtor can be detained for a period not exceeding 3 months. Therefore, below 5,000, it is 6 weeks, not exceeding 6 weeks. If it is above 5,000 without any limit, then the period of detention can be only up to 3 months. Beyond 3 months, a judgment debtor cannot be placed in detention. Then now, whether they can be released after putting the judgment debtor in detention and he is serving that detention in a civil prison, can he be released? Then there are certain ways by which the judgment debtor is released prematurely. That is, before the expiry of the period for detention, by order of court. The order of court is always necessary in case the amount mentioned in the decree is paid. The amount of the decree mentioned in the decree plus the cost of detention, if paid to the judgment debtor, and if it is brought to the knowledge of the court, then the court will release him forthwith. Then, if the amount is otherwise paid, suppose if the amount is by private arrangement paid, then also when it is informed to the court that the amount has been fully satisfied, then also the court will release him. Then, on the request of the person on whose behalf or at whose instance the judgment debtor is put in civil prison, he can be released. That means that he is satisfied about the amount payable to him. Therefore, if the decree is satisfied and if it is brought to the knowledge of the court, then he will be released. Therefore, it is stated in that section, on the request of the decree holder, he can be released. Suppose I have told you that a judgment can be placed in detention only by on the cost of the decree holder. The decree holder has to pay the subsistence allowance that is prescribed by the government. If the subsistence allowance is not paid, then also the detainee can be released prematurely. Therefore, these are all 4 conditions under which a judgment debtor can be released prematurely. The next is, there are one other ground, that is on the ground of serious illness. This after a warrant of arrest is issued by the executing court, if the person against whom the warrant of arrest is issued is found to be in serious illness. If he is suffering from serious illness, then also he will be released. But the condition being that the arrest warrant must have been issued. That means in anticipation of issuance of an arrest warrant, he cannot get a release. But the court has to get satisfaction about the illness that he is suffering from. Only on that ground alone, the warrant of arrest will be withdrawn or cancelled. The next is, suppose if the detainee is not in good health, if it is not fit enough to serve the period of detention, then also the court will release him prematurely. Then by the government, also suppose if the government says that there is a prevalence of contagious disease or infectious disease, like nowadays the corona, if the government feels putting a person in civil prison is dangerous to his health because of the prevalence of any contagious or infectious disease, then also the court will release prematurely. Then a higher court or the court itself which passed the order feels that it is unnecessary to keep a person in detention for the fault of payment of the money, then also it can pass an order releasing him, or by the intervention of court also he can be released prematurely. Then one thing you must understand is that whenever a person is released on the ground of illness and also under section 59 before expiry of the period of detention, then the court can rearrest him. In case he is not found eligible for the premature release, then the court can always order him for detention, further detention. But this detention, one condition must be satisfied, that beyond the period which I have already stated, that in case of amount that is above 2,000 and below 5,000, 6 weeks, and in case of more than 5,000 up to a period of 3 months, if it should not exceed those periods. Therefore, the court will make it certain, though he may be rearrested, but the court will keep it in mind if he has served the full sentence, the full period of detention, then beyond that period, even rearrest will not arise. Therefore, rearrest will arise only for the remaining period, not for period beyond the period already prescribed in section 58. Then one more thing you must remember is that by reason of detention, the amount payable under the decree will not be extinguished at all. The decree, but the judgment debtor will always be liable as long as it is not satisfied. The decree amount is not paid. Therefore, only on payment of the entire amount that is sought to be executed is paid to the decree holder, he will be fully discharged, but not by detention. By detention will not wipe out the liability of the judgment debtor to the decree holder. Therefore, you must keep it in mind. And next is section 60. Section 60 is an important provision in the CPC where it is provided what are the articles or the properties that can be attached and what are the properties that cannot be attached in execution of a decree. Therefore, you have to go through section 60 for the purpose of understanding what are the properties that are liable to be attached in the hands of the judgment debtor. Therefore, there is a list given in section 60. And also the next proviso or the next limb of that section provides for the properties or the articles in the hands of the judgment debtor that cannot be attached. Therefore, the case law will arise or the complication will arise more on the question whether a property is liable to be attached at all. Therefore, the decree, but the judgment debtor will always try to defeat the execution petition filed by the decree holder, saying that the property now sought to be attached is not attachable. It cannot be attached. Therefore, the legal complication will arise only when the judgment debtor raises a question that the particular property which is now brought for attachment or sale is not liable to be attached. Therefore, the question will arise, more question will arise on the question whether a particular property is attachable or not. Therefore, any judgment debtor in a flush will take that defense only. Therefore, you have to go through the both limb of the section 60. regarding what are the properties that can be attached and also what are the properties that cannot be attached. Then you have to understand one particular thing, that the execution is a difficult stage in the course of a litigation. As a matter of fact, the headache of a decree holder will arise only after he obtains a decree. Even it may be easy for a person, a plaintiff, to get a decree, but it is much more difficult to get a decree executed. Therefore, execution is the difficult part or a complicated part, stage of one's litigation. Therefore, you must be very thorough about the provisions that is contained in section 60 regarding the execution of properties that are attachable and the properties that are not to be attached. Therefore, by law, certain properties are exempt from attachment, and you have to concentrate more on the properties that cannot be attached by reason of this law provided in section 60. Now I will read fastly the properties that can be attached. But one thing you have to understand, all the saleable interests are the properties over which the judgment debtor has a saleable interest are the properties that can be attached, unless it is specifically exempted in the other limb, in the limb of the provision that is now I am going to mention a moment later. But you have to say, first of all, that you must keep it in mind, the saleable interest in the property will alone weigh whether the judgment debtor is owning that property or not, or having possession of that property or not. Therefore, if the judgment debtor has a saleable interest in the property sought to be attached. Therefore, what are those properties? Lands, houses, other buildings, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, government securities, and other securities for money, debts, shares in a corporation, and all other saleable property, movable or immovable, belonging to the JD, which are profit, or these properties may be held by another person in trust for the judgment debtor, or on behalf of the judgment debtor, some other person may hold that property as a trust. In those cases also, that property can be attached, though it may be in the hands of the other person, and he is holding it in trust or on behalf of the judgment debtor. That can be attached. Then exception. What are the properties that cannot be attached? Kindly you take a note of it, and wherever it is more important, I will highlight those articles or the properties which cannot be attached. Now, the necessary wearing apparel. A person or a woman, both male and female, may have some wearing apparel which cannot be detached from the body by reason of any religious faith or anything else, a religious faith or customary belief. As a consequence of this customary belief or a religious belief, if any ornament is worn by a person, both male and female, that cannot also be attached. Cooking vessels and beds, beddings of JD and his wife and children, and such personal ornaments as in accordance with religious usage cannot be parted with by any woman. I will concentrate on the article or a jewel that is worn by a woman. Suppose a thali of a woman, that cannot be attached, because by religious belief it has a religious significance. It cannot be parted with by a woman. And also mitti and other ornaments which represents a faith or a custom. It is rooted in custom. In respect of those articles found on the body of a woman, it cannot be attached. You keep it in mind. Likewise, tools of artisans. Artisan means any person who uses that tool for earning his livelihood. A painter, brush. Likewise, a person who uses some instruments for the purpose of executing a work in which he is engaged for his livelihood. In those cases, these instruments of his profession or occupation cannot be attached. Likewise, a plow of an agriculturist cannot be attached. And also seeds. Likewise, it is given. A JD is an cooking vessel beds, tools of artisans. If the JD is an agriculturist, his implements of husbandry and such cattle and seed, grain, as may, in the opinion of the court, be necessary to enable him to earn his livelihood. Therefore, those implements or articles or even it can be said, these are tools that are used for. Madam, am I audible? Hello?
Yes, sir.
Am I audible?
Yes, sir. Koncha vitti varudhu, sir.
Yeah.
Yes, sir. Now you are audible, sir.
Right.
Now
Yes.
you are audible, sir.
Yes. Then agriculturist using tools like plows, cattle, and also bullocks. These are all articles which an agriculturist uses as an instrument for operation or his occupation. And also these occupations are done by those persons only for their livelihood. In respect of those articles also, there cannot be any attachment. And houses and other buildings belonging to agriculturists. If an agriculturist is owning a building and a laborer is owning a building and a domestic servant owning building, those buildings are all exempted. Then agriculturist, who is an agriculturist, that is also defined in the proviso that is given in section 60. I will come to that part a little later. Now, other articles which are exempt from attachment is books of accounts, a mere right to sue for damages, because it is contingent upon happening. Yeah, something happening. It is not in the possession of the judgment debtor at the time when a decree is passed or when an application for attachment is filed. Therefore, it must be in the possession of the judgment debtor when the petition for attachment is filed. Therefore, any future interest that may arise in future on the happening of some event cannot be treated as a property in the hands of the judgment debtor. Those properties cannot be attached. In anticipation, that property which is sought to be attached will come to the hands of the judgment debtor on the happening of some event cannot be attached. Then any right of personal service, stipends and gratuities. This is important. Stipends, gratuities allowed to pensioners of the government, local authority, or any other employee payable out of this service family pension fund notified by the central government or state government and political pension. Here, any gratuity that is payable to a servant working in the government or any local body, and such of those portion of the salary which are declared by the government exempted from the attachment, those portion also cannot be attached. That is stipends. That is like stipends and also gratuities. If then one more thing is not attachable is political pension. Suppose for consideration of the service rendered to the government, a government may allow or confer a benefit in the form of a pension. Suppose freedom fighters pension given by the central government. Even state government is also giving freedom fighters pension. These are all political pension. Likewise, the privy pearls given to former rulers of Indian states. On merging those states ruled by former rulers, a privy pearls was given. That privy pearls was given as a pension. It was treated as a political pension. That privy pearls also declared to be not attachable. It cannot be attached, but it comes under the definition of political pension. Therefore, in a case decided by the Supreme Court, it has been held that the political pension, even it is a privy pearls, cannot be attached. Now, the wages of a laborer and a domestic servant cannot also be attached. Then salary. Then we'll come to an important facts are an important matter in the list of articles or the properties that can be attached. That is salary. Suppose salary earned by a person, whether it is liable to attachment. Suppose salary or the salary is attachable. But when salaries are to be attached, you have to distinguish between two kinds of decrees. One ordinary decree for money and another decree for maintenance. A wife filing a petition for maintenance and that maintenance has been ordered by way of a decree. Therefore, you have to keep in mind two types of decrees. When it comes to execution of money decree, this money decree is divided into two kinds. One is a decree for money and another is a decree for maintenance, because the amount varies or the portion of the salary that is sought to be attached, it varies by way of execution. Therefore, in respect of salary, not the decree for maintenance, in respect of execution of a salary, then the salary, suppose take for example, first 1,000 rupees is not attachable. That if a person draws a salary, an amount as salary, and out of that salary, first 1,000 rupees is not attachable. Then 2/3 of the remainder is also not attachable. Therefore, first 1,000 and 2/3. Suppose take for example, 10,000 rupees a person draws. The judgment debtor is getting 10,000 rupees as monthly salary. Out of which, if a decree for attachment is passed, the court will pass the order attaching attaching 2/3 only, 2/3 of the remainder after deducting 1,000. Suppose 10,000, first 1,000 is not attached, cannot be attached. Then regarding the 9,000 rupees, that is the remainder. Out of that remainder, 2/3 is attachable. Therefore, 2/3 means, suppose out of 9,000, 2/3 is 6,000. And the 6,000 cannot be attached. And also the first 1,000. In all, 7,000 rupees cannot be attached. What is available for attachment in respect of a ordinary decree for money is only 3,000 rupees. You please take note of it. Out of 1,000, first 1,000 is not subjected to attachment. Then the remainder 9,000 rupees, only 1/3 alone is available for attachment. That means only 3,000 alone can be attached out of a salary earned by a judgment debtor. Then with regard to maintenance decree, there is a difference. In respect of a decree for maintenance, the person suppose wants to attach a woman. You take for example a woman who got an order for maintenance, a decree for maintenance. It can also be attached as against the salary of her husband or of a person. In those cases, only 1/3 alone exempted. That means out of 10,000 rupees, this first 1,000 and also 2/3, it will not be applicable. Here, only 1/3 alone is exempted. That means 2/3 of the salary is liable for attachment in respect of a decree for maintenance. This is the difference. You have to keep it in mind. Here, 2/3 is available for attachment. In the former case, that is a decree for ordinary money. First 10,000 and also 2/3 exempted. There were more money available for attachment by attachment in execution of a decree for maintenance. Therefore, you have to keep it in mind. And here, 1/3 means only 3,333 rupees alone exempted. The remaining rupees, 6,667 is available for execution in respect of a decree for maintenance. Then one more salary is also exempted. That is pay and allowances payable to persons who are working as airman in the Air Force, army man in the army, and also Navy. But in all these cases, if their salaries are regulated by these acts, you kindly take it down. Air Force Act 1950, any person receives a salary as per the Air Force Act 1950, and also any person receiving a salary as per Army Act 1950 and Navy Act 1956, they are all exempted from attachment. Therefore, it is a concession given to the army men, soldiers, and also persons who are working in the Navy. These are all salaries consciously exempted from attachment. All compulsory deposits, likewise, the compulsory deposit in the sense, Provident Fund. Provident Fund is nothing but a Shema Nala Nidhi. It is a fund. It is created out of compulsion for the purpose of paying it to the employee at the time of his retirement. A lump sum amount. This lump sum amount is kept as a fund. To that fund, not only the employer but also the employee who is working should contribute. Therefore, both are contributing to the to that fund. Then on maturity, that on maturity means at the time of retirement, this provident fund will also be made available to the person who retires. Therefore, this is a compulsory deposit made under the provisions of the Provident Fund Act. This Provident Fund is also exempted from attachment. And with regard to the policy of insurance, suppose if a person takes a policy for life, or in the contingency of his death, he will be paid that the amount under the life insurance by taking a policy. Therefore, a person who insured his life, is also, that amount payable on his death is also exempted. Any amount payable by virtue of a policy for life insurance is also exempted. That is, all monies payable under a policy of insurance on the life of the judgment, debtor is exempted from attachment. And any person who resides in a rented house, this lessee also may have some right as in his capacity as a tenant. Therefore, in his capacity as a tenant, whatever right he has as a tenant under the relevant rent control act is also exempted from attachment, because he is not the owner of the property in which he resides. He is only a tenant. Therefore, any right that is conferred on him by virtue of any rent control act, that right is also not attachable. That is exempted from attachment. Then, in cases of succession to properties by survivorship, you have to study it. Yes, there are two modes of succeeding to the property of a deceased person. One by survivorship, and also one is laying claim as a legal heir on the death of the person. Therefore, in devolution, in these two cases, there is a difference, survivorship and also laying claim as by virtue of or devolution of property. Therefore, survivorship means only on the death of a person, if he is a member of a joint family, he will get a right or unascertained extent of property in the property owned by the joint family. In those cases also, he will not have any definite share in the property of the common family or joint family. In those cases also, his part, which is unascertainable, cannot be attached. Therefore, any succession by way of survivorship cannot be attached. Then, right of future maintenance cannot be attached. Then, one explanation is given: who is an agriculturist? I have told you that the income of an agriculturist is exempted. Or a person who occupies a house, and also a tenant who occupies a house, and if a person is a domestic servant, and they are earning their livelihood by operation of agriculture, in those cases their income is not attachable. Then a question will arise: who is an agriculturist? Agriculturist is a person who cultivates land personally, and also who depends upon that income from agricultural land for his livelihood. Therefore, both conditions must be satisfied. That is, who must the person who claims as an agriculturist must personally cultivate the land, and also he must derive that land on account of his work in the field as an agriculturist. And in those cases, he may be a owner or a tenant or a partner. Partner means in the agricultural operation, he is a partner with another person, or an agricultural labor. There was any income which they earned from actual labor in the agricultural field. And also if they get income out of their work, then that income is also exempted. And cultivate personally is also defined. I have said to you that a person who cultivates personally, is also defined in explanation 6 of section 60. A person who cultivates land by his own labor, who he himself enters the field and he works by exertion of his physical body. Therefore, if he by his own labor, if he works, then he is treated as an agriculturist. Then by the labor of his family members, children, or son, daughters, wife, if they also engage in the agricultural operation, the person is called an agriculturist. And suppose if he engages a labor and he pays them the wages, then he is also an agriculturist. Not only the labor, but the person in whose favor the labor works in the field, and by means of which he engages himself in the agricultural operation, he is also treated as an agriculturist. Then one more important aspect of this exemption is, this exemption cannot be waived at all by means of an agreement. What are all the articles or the properties which I have said are exempted from the operation from attachment, that cannot be by virtue of an agreement between the person who gives the money and also who gets the other who gets the amount, cannot be waived at all, or a decree holder and a judgment debtor cannot enter into an agreement waiving the exemption. The exemption in respect of any agreement or clause in the agreement that gives a waiver of that exemption, that is void. That it cannot be waived at all. Then in case a judgment debtor says that a particular property cannot be attached because because he is an agriculturist, when he raises this plea or this objection in an execution petition, then the onus of proof that he is not an agriculturist will always lie on the decree holder, who asserts that the judgment debtor is an agriculturist. Therefore, the onus of proof that the particular person is an agriculturist is always on the person who asserts that the other person is an agriculturist, or the judgment debtor is an agriculturist. Therefore, the onus of proof always is resting upon the person who asserts, that is the decree holder. And the next thing, or property that cannot be attached, is the death cum retirement gratuity, provident fund, and leave salary payable to the deceased employee and kept in trust by the employer. Therefore, if any money is kept by the government and that is payable to the employee in the form of death cum retirement gratuity, provident fund, and leave salary, cannot be attached. Whether it is in the hands of the government before payment or after payment to that particular employee, this amount cannot be attached. And the case law in regard to this, that two proposition of law. One is whether a particular person is an agriculturist or has to be proved by the decree holder, or the person who asserts that the judgment debtor is an agriculturist, not an agriculturist, it rests upon the person who asserts. The case law on that subject is, kindly take down, 2005 4 CTC, page 194, Dharmam versus Chinnathambi. Then the death cum retirement gratuity, provident fund, kept in trust by the government before payment and after payment cannot be attached, is upheld by the decisions of the Honorable Supreme Court in 2004, 2 CTC, page 129, and another AR 1976, Supreme Court 1163. The equivalent is 1976, 3 SEC 607. I have said to you that privy purse is also a political pension that cannot be attached. This case is decided by the Supreme Court, and the decision is reported in AR 1965, Supreme Court 1798. And one more criteria to decide whether a person is agriculturalist. It is a common understanding is a person who does not till his soil, till, T-I-L-L, till. A person who doesn't till his soil is not an agriculturist. This is a common understanding. Then you have to understand what are those exceptions. And you have to decide a case with reference to the exemption. Already I have told you about who are all agriculturists. But the common understanding of law with regard to this, who is an agriculturist or who is not an agriculturist. In a case, it has been decided. A person who doesn't till his soil is not an agriculturist, or he must only depend upon the income from out of his labor or out of his tilling of the soil, and his livelihood, he gets his livelihood only out of the work or labor he expends on his property by tilling. Only in those cases he will be treated as an agriculture. That is also upheld. This case is also reported in AR 1961, Supreme Court 589. Then I have told you about the attachment of the salary. And this attachment of the salary, I have already told you that first 1,000 and also the next 2/3 in respect of ordinary decree for money is not attachable. But now a question will arise. Suppose a person doesn't get the salary at all. In the sense, the government or the person who engages the services of an employee doesn't pay periodically, but with the result, the salary gets into arrears. The government doesn't pay it, therefore it accumulates as arrears of salary. Whether this arrears of salary is exempted from attachment, this is a question. But the court has held that the arrears of salary thus accumulated is liable to attachment. It does not get any exemption, as I have stated in section 50 in the previous sections. That is section 60. What the salary, I have said first 1,000 and also 2/3. This ratio will not apply to arrears of salary. Arrears of salary is liable to attachment in its entirety without the concession that is given in the previous limb of the same section. And this is also decided in a case reported in AR 1952, Supreme Court 227, 1952. This is say equivalent. 1952, 2 MLJ 265, Union of India versus Hira Devi. This is the case wherein it has been decided that arrears of salary accumulated is not is liable to be attached in its entirety. There is no concession. And retirement benefits also cannot be attached, both when it is in the hands of the government and also after payment to the judgment debtor. Any government also from time to time may announce that certain produce of the agriculture is also not liable for attachment. It is up to the government also. Suppose the government can also always exempt the agricultural produce, saying that this portion of the agricultural produce is not liable for attachment. It is in the hands of the the government also. Then seizure of property in dwelling house. Dwelling house, I have already come across this dwelling house in another section. Then suppose the property that is sought to be attached is in the hands of a person who sets himself up in a dwelling house. Whether the front door of that dwelling house can be broken open. Yes, that can be broken open, but before sunset, before sunset and after sunset. Therefore, after sunset and before sunrise, this property cannot be broken open. But in cases where it is in the occupancy of the judgment debtor, it can be broken open after giving sufficient warning, and also in cases when the judgment debtor resists and also prevents the arresting officer or detaining officer from executing the decree. And also then in respect of Padhanashin woman, a woman who will not come out in public according to her custom, and if the property is in the occupancy of that woman, in those cases also, sufficient time has to be given to those women to withdraw themselves from the sight of the arresting officer or any other person who comes with him to go into seclusion, so that the judgment debtor who is hiding there inside your can be either detained or the property there can be attached. These are all provisions relating to execution of the decree. Suppose a case may arise wherein, in respect of the same property, several persons might have filed a suit in several courts. Suppose if the decree as against the property owned by a judgment debtor is passed by several courts, there were all the decree holders in all the courts may try to execute their decree in their respective courts, but against the same decree, against the same judgment. Therefore, a problem will arise: which court will have jurisdiction, or or which court is entitled to decide the questions with regard to the attachment of that very same property in respect of decrees passed in various courts. A dilemma will arise. In such of those cases, suppose anything that has to be decided with regard to the propriety or otherwise of such a decree, then if the 4 suits concerning the very same property against the very same judgment debtor, and this attachment is sought to be made in respect of that property in all the 4 courts, then which is the court that can decide the matter? There were not all the courts, because it will result in conflict of decision. Therefore, it is desirable that only one court alone decides the issues raised by the judgment debtors or any decree holder even in respect of those decrees. It can be only by one court, which is that court. Suppose if the 4 courts have given decrees or delivered decrees in the hierarchy of courts, which is higher in grade, the court which is higher in grade will entertain the applications in respect of the decrees pending in all other courts. Out of the 4, if there is a court higher in grade, suppose if all the cases are pending in 3 municipal courts and 1 subcourt, and in those cases the subcourt is the court which is higher in grade, that subcourt will decide the cases relating to all the decrees and also all questions arising from those decrees and all the other courts, including the case that is pending before the subcourt. Suppose in case all the 4 courts are similar in grade, all municipal courts or all subcourts, in those cases, the court which entertained the application first, if all the courts are similar in grade, or equal in grade, then in those cases, the court which entertains the first application or the court which is approached by a decree holder in one of the courts, that court will alone have the jurisdiction to decide all matters pending before all the courts. Therefore, you have to take note of this. And Section 64 is an important section, 64. Suppose a property is attached in execution of a decree, and the judgment that are deals with that property by entering into private transaction or private alienation to third parties, whether that alienation is valid. Section 64 says it is void. Any private alienation made by the judgment debtor in respect of a property over which there is an attachment effected on the application of the decree holder, then that sale, that private sale executed by the judgment debtor is invalid, void. Then it is section 64. This is a wide statement provision given under section 64. Here, what you have to understand, there are exceptions, whether it is void in all the cases. That you have to understand by a closer reading of this section, and also decisions rendered by high courts and also the Supreme Court in various cases. By reading those cases, you will understand the differences. It is not as if all the private transactions or the private sales executed by the judgment debtor is invalid. But the general proposition is, if a straight question is asked, whether a private alienation made by a judgment debtor in respect of a property over which the decree holder has obtained an attachment order is valid, it is void. Then comes the exemption. One thing you have to understand is, as soon as a property is attached by reason of an execution, it doesn't mean that the decree holder loses his ownership over the property. In spite of the order of attachment passed in respect of a property, the judgment debtor doesn't lose his ownership over the property. He will lose the ownership only after the sale. Only after the sale is effected, the ownership of the judgment debtor will come to an end. Till then, he continues to be the owner. Now, what is the exemption? Now, the exemption is the private sale or private alienation done by the judgment debtor in violation of the rights that arose in favor of the decree holder by reason of the attachment alone void. There were such of those transactions in violation of the right as against the right of the decree holder by reason of the attachment order will alone become or will alone be rendered invalid or void. Other transactions that arose from some other reason, which is not the subject matter of the attachment, then that's are valid. As I have said to you, that you have to keep it in mind. He continues to be the owner till it is sold. Therefore, there is some right, if left, in the hands of the judgment debtor, and that right is legally to be transferable to somebody else, and the somebody else is having a right over that property as against attachment order passed in favor of the decree holder, then to that extent, that private sale or private alienation is valid. What are those occasions? Suppose, take for example, a judgment debtor has already entered into an agreement for sale with a third person. But before the attachment is made, you have to understand that before the attachment is made, if any agreement is made for sale with a third party by the judgment debtor, and also it is registered, but you take note of it, registered also. Registration makes some sense, or it has some significance. I will explain to you a little later. Therefore, you have to understand that if any agreement for sale or if any other agreement is made, which is made prior to the attachment and also registered, and in consequence of that agreement, some right flows in favor of the third party legally, then that the third party will get a valid title. Here, suppose if the agreement for sale is effected and that sale is entered into, or the sale is executed, sale deed is executed and registered prior to this attachment order, then it will not be affected. Even the sale might taken place after the attachment, but it will not invalidate the after attachment, if any private sale is made in consequence of a previous agreement executed earlier and also registered earlier prior to registration, and the sale is executed after the attachment, it will not be hit by the prohibition contained in section 64. Therefore, to that extent, the ownership of that judgment debtor is upheld. Here, you have to understand section 40 of the TP Act also. Only for the purpose of understanding, I will give you a brief facts about that section 40. Section 40 deals with agreements. But section 40 says an agreement is not a conveyance. By agreement, you cannot convey property. It is an agreement by which one person agrees to sell it to another person for sale consideration. But it will not create any right in the property. But on the contrary, the proviso to section 40 of the TP Act says that whenever an agreement is made between two persons, owner and the purchaser, it creates an obligation on the part of the owner with regard to his ownership over the property. Therefore, the obligation attached to the ownership of the property comes into play. Therefore, if their obligation relating to or touching on the ownership comes into existence, then it will continue to go with the property. This obligation over the ownership of the property will continue to go run with the obligation or run with the property. Therefore, wherever the property goes, it will carry that obligation. This obligation is recognized by a court of law or by courts. Therefore, though it doesn't create a right in favor of the purchaser, it creates an obligation on the part of the owner, the vendor. Therefore, that obligation is attached to the property. Therefore, wherever the property goes, that obligation will continue to remain with the property. Therefore, any person who with notice and for no consideration purchases the property, that sale is protected. It will not be hit by section 64. Then for a better understanding, you kindly read 2005 3 CTC page 640. And the next case, it is an important case. This obligation running with the property, obligation with regard to the ownership running with the property is 1990 3 SEC page 291. This is an important decision. I request all of you to read it for better understanding of this the consequence of a sale, private sale during the pendency of the order of attachment. And next case is 2006 5 CTC 245. Therefore, you read all these three cases together and understand. Then one more case is 2002 5 CTC 1884. Equivalent is 2002 3 MLJ 229. These are all cases dealing with the same subject. Then how is the attachment raised? Suppose the attachment is in force. What are the circumstances under which an attachment order passed by a court can be lifted or raised? There are three sections which deals with this termination of an attachment order. That is given in section. You have to if you want to understand better section 64, then you have to read section 20. You take down order 21 rule 55, order 21 rule 57, and order 21 rule 58 are all the rules 55, 57 and 58 of order 21 have to be understood or have to be read and understood when you read section 64 also. These three rules deal with occasions when this attachment order came to be terminated. First is Order 21, Rule 55 says that the amount decreed with cost with all the charges and expenses resulting from attachment is paid to the decree holder. They will give the amount mentioned in the decree along with the expenses that the decree holder incurred for getting the order of attachment. If paid to the decree holder, then if it is informed to the court will terminate the order. Second is not only it has to be paid before the court. If it is paid otherwise also out of court, then also if it is informed to the court that the money has been paid and the decree holder is satisfied of his decree, then also the court will terminate the decree. Then if the decree is set aside by a higher court, if the decree on the basis of which the execution is sought to be made is reversed or set aside by a higher court, then also automatically the attachment will come to an end. Then Order 21, Rule 57 speaks of another set of occasions wherein the attachment order will come to an end. Here also, if the court passes an order dismissing the application for execution, suppose these attachments might have been made as an interim measure, and also on hearing parties and also on hearing the parties elaborate, if a final order is passed on the application wherein the court is not satisfied with the claim for attachment and the executing court dismisses the application for attachment, then that attachment will come to an end on the day when the court dismisses it. And sometimes the court will, while dismissing the application for attachment, may say that this attachment will continue for such and such time. Then also, though the attachment order is raised, though the application for attachment is dismissed, the court may say for such and such a period, the attachment will continue to remain in force. Then also that order will continue till such a time as the court passes the order. Then the next occasion is Rule 58 of Order 21, 58. Then, as I have said, the person against whom the attachment is sought to be made, or against whom such an order of attachment is made, or say for example the judgment debtor, then if he raises an objection saying that this property cannot be attached at all, and if the court upholds that objection or agrees with the objection raised by the judgment debtor, then also the court will terminate the order of attachment. There were these three occasions wherein the court will pass an order saying that the amount or the order of attachment is terminated, is given under Order 21, Rule 55, 57, and 58 of CPC. And by operation of, these are all apart from those three stages, which is contemplated under Rule 3, or 3 rules of Order 21, by operation of law also. This is one more occasion or circumstance under which the order passed for attachment will come to an end, will get terminated by operation of law. Suppose if an intervening law comes into force, say for example a debt moratorium, or suppose the government announces for the corona period people have suffered, therefore all attachment made in courts over the properties belonging to such and such person or such persons who suffered corona will automatically stand terminated. In those cases also, the government order will be taken note of and the order of attachment will be terminated. In these, with regard to these cases, kindly take down the case law. 2010 5 CTC 606, it is a Supreme Court order. 2010 5 CTC 606. Next case on the subject is 1994 JT judgment today. 1994 JT 391. Then AR 1975, Supreme Court 1810. And next is 1971, 3 SEC 878, 71. These are all cases dealing with the termination of an order of attachment. And next is section 65. Section 65 deals with purchase sales title. The purchaser, when he gets the title, full title, is now given under section 65. The purchaser means a court auction purchaser from the hands of the judgment debtor in execution of the decree. The purchaser will get title over the property when the sale made in his favor is made absolute. That means whenever the court which sold the property in execution of a decree, it doesn't mean that on the day when the property is sold in auction will confer an absolute right on the purchaser of the property from the judgment debtor. It will be a preliminary order, or it can be taken as a preliminary sale, but it is sale only. But in order to give an opportunity to any objections or any objectors who want to raise an objection about the sale, in order to give that opportunity, the court, out of abundant caution, will pass an order directing sale only. That sale will be taken note, but the sale will not be confirmed. But after a month, the court will pass an order. After hearing objections, if any, the court will pass an order making the sale absolute. Therefore, according to section 65, the purchaser will get absolute title only on the day when it is made absolute. It made absolute. But once it is made absolute, then it relates to the date of sale. When it was made, that sale was held and not made absolute, or it was not confirmed. It was a sale. Therefore, when it is made absolute, it relates back to the actual date of sale. He becomes the owner from that day. But actually, he gets absolute title on the subsequent date. But on getting that date by the absolute sale, or the sale made absolute, then the ownership over the property to the purchaser relates back to the time, or the time when it was sold. This is a matter which you have to keep it in mind. Then proceeds, section 73 deals with rateable distribution. If there are several decree holders against a particular judgment debtor, and all are having decrees in their favor for money, and in respect of the very same property they want to proceed, then in those cases, this property will be sold in auction, and the money will be deposited in the court, and the court, after defraying the expenses for conducting sale, then it will rateably distribute among the decree holders. Then suppose if a particular court grants a decree and some other decree holder also comes into picture saying that we have also obtained decree, but first decree, the priority will be in favor of the decree holder who obtained the decree in that court. Therefore, after satisfaction of the first decree holder, for the remaining decree holders, it will be rateably distributed after deducting the expenses for the sale. But in all the cases of sale, the court will first of all deduct the expenses incurred by the decree holder for sale. Only after deduction, the remaining amount will be distributed among other decree holders rateably. That means proportionate to the amount for which they have obtained the decree. Here also there is one exception will arise. Suppose if the property which is sold in auction by the court is subject to a mortgage, but the mortgagee will not get any preferential right. That means he will not get any share in the surplus amount. Suppose if the property is sold for a certain amount, and also if the amount is distributed among the decree holders, and if any surplus is left, the the mortgagee will not get any share in the surplus. This is, there is a prohibition. He cannot get a share. But on the contrary, whatever right he has got by virtue of advancing money to the decree holder, and that property is subjected to mortgage by him or with him as a mortgage, then the mortgagee can enforce his mortgage and get a decree. That therefore he has to approach a court of law and enforce that judgment only. Sorry, the mortgage only. Therefore, apart from that right, the mortgagee has no other right over the surplus amount that is deposited, that is kept deposited in the bank. Then with regard to the priority. Suppose if the government debt is there, if the government is there, any crime of the government is there in respect of the very same property, then the government gets priority. But how that priority is protected and to what extent the government will get the priority over the amount deposited in the court, that is dealt with in section 79. 79 deals with the priority of the government. Here you have to understand, government has some priority over the amount that is realized by virtue of sale of the property of the judgment debtor. Suppose the judgment debtor has to pay some amount to the government. There is a distinction between, first of all, you have to study the case laws rendered on section 79 very thoroughly, because it is a minute point. It may be confusing also. Therefore, you have to understand very properly by reading the case laws. Only when you read the case law, it is a debatable point. But I will tell the principles in a simple words. But I cannot say that these explanations or my lecture will clear your confusion. But it is a confusion-ridden section. But anyway, I will try to explain to you what is the priority of government. Priority of government is, suppose if the judgment debtor is owing money to the government, and the money is compulsorily exactable from the judgment debtor, say for example, income tax, sale tax, and also any other tax. These taxes are not with reference to any service rendered. The tax are compulsorily taxable from a person who is having the money, or money having come to the person, and he is liable to pay to the government. This compulsory exaction of money from the citizen is the prerogative of a government. That means that represents a sovereign power of the government. Therefore, when the money is payable from its citizens as a result of an exercise of a sovereign function, or in exercise of its sovereign authority, then that amount is always getting priority over any other debt. Even an order passed by the court of law attaching the property of a private citizen will first of all give way to the claim by the government. The claim of the government payable by the judgment debtor, and all that also, that power has been exercised in its sovereign function and also representing its sovereign authority, then that is a priority. Then comes the exemption. Here, suppose if a property is now pledged with a judgment debtor, or a property is mortgaged with a property is mortgaged by the judgment debtor. In those cases, the property is kept by him as a bailey. In those cases, such property cannot be attached, because that person who gets the money or who gets that property of the judgment on paying his money. Therefore, it has to be kept as security. Therefore, when the security is in the hands of the judgment, that cannot be taken away by the government. Here only comes the confusion. But I will say a little later. But here, suppose as a mortgagee he is holding the property, and as a pledgee he is holding some articles. Whether it can be attached by the government as priority or in exercise of its priority, or a priority is now conferred. Here, a clear distinction is given. In cases where the property is held in trust or as a security, then the court, but the government has to give way to such of those transactions. But in respect of cases where the decree is not out of a security or an ordinary money decree, then in those cases the government may get a priority. But in such of those cases where the property sought to be attached is in the hands of the judgment debtor as security, then the government has to give way. Anyway, you will understand by reading those case laws here. This is the distinction. So 2004 3 CTC 696. This clearly brings about the distinction between the decree that is ought to be executed by the government and also by the person who is another ordinary decree holder. 2004 3 CTC 696. Then 2005 SEC 694, 1985 to SEC 40. Have you taken down? 2004 3 CTC 696, 2005 SEC 694, 1985 to SEC 440. Then section 74. Section 74 is resistance to execution. If any person resists or prevents execution of a decree, then either the decree holder or any person who aids him in preventing or resisting the execution of the decree, then they can be put in civil prison at the instance of the decree holder. Therefore, it is provided under section 74. Nobody can prevent or resist execution by the court of a decree passed in favor of a decree holder. Then section 75 deals with power of court to issue commission. The court may issue commission to a court in another state, and this commission can be issued for the following purposes. I will say the purpose. The court may issue a commission to examine any person who is residing within the jurisdiction of another court in another state. Likewise, to examine any person and to make a local investigation, to examine or adjust accounts, to make a partition, to hold a scientific, technical or expert investigation, to conduct sale of property which is subject to speedy natural decay and which is in the custody of a court pending determination of the suit, to perform any ministerial act. Therefore, court can issue always a commission for these purposes. And also one thing you have to keep it in mind is an advocate commissioner, if appointed, whether he can go into a question as to who is in possession of a property. Therefore, the question who is in possession of the property can be decided not by a commissioner. It has to be decided by the court while dealing with the case of both the parties, plaintiff and the defendant, on the basis of the documents and also the evidences produced before court. But It is not the function of the commissioner to see who is in possession. It cannot be done at all. Therefore, there's a clear prohibition. A commissioner, if appointed by the court, can decide matters or can record such of those matters which are provided under section 75. That is five matters. But beyond which, and especially whether he can be authorized to make an inspection in order to ascertain as to who is in possession, it is prohibited. That is, there's a case reported, that is 1998 to CTC. Then commission of another court. These are all we will deal with on the next date of my lecture. But I am stopping it with the section 75. I will commence my further lecture from section 76 on the next date of session. Right. Thank you, sir.
Thank you. Thank you very much, sir. It was a really excellent session.